Hello and welcome to the 21st episode of Wahl on Law. My name is Jonas Wahl, and I am a pre-law student at the University of Delaware. On this podcast, we cover what's happening across the country in law and policy and how it affects your daily life. Today, we're joined by a special guest, Amanda Sima, who is a business owner, patented inventor, and author, to break down the realities of intellectual property law and what happens when protecting an invention becomes more complicated than just getting a patent. Ms. Sima, thank you so much for joining me today.
Thank you for having me.
Before we get into the legal side of things, could you first tell us a little bit about your background and how you first got involved in entrepreneurship?
Sure. Out of college, it's funny, this is a law podcast. In college, I majored in history because I thought I wanted to go to law school. And I took one pre-law class and I was like, oh, that's not for me. So I'm like, oh my gosh, what am I going to do with a history degree? And at the time, I was very interested in politics. I graduated from Ohio State University and I got a job on a campaign, a governor's race there in the state of Ohio. And they threw me into fundraising. And as a result of fundraising, I met donors from across the state, many of which were just self-made entrepreneurs. And I'd always kind of been a creator and created on the side. But I think after meeting these self-made entrepreneurs, it really manifested in my mind that, wow, I could, really make a living from this. And that's really what kind of, I would say, gave me the entrepreneurial bug.
That's so great. And since getting this bug, you've invented quite a few things, right?
Yeah, I mean, I've invented things that aren't in market. I've invented things that are in market, but definitely all of my creations, most importantly, are literally just from my brain. It's like just an idea popped into my brain about what could maybe fix a certain problem in any given industry. My first business was an apparel line in the NCAA licensed industry. So at the time, a lot of people were wearing Ohio State t-shirts and sweatshirts, but there really wasn't any like fashion. And so I created a line of sweaters. And then I grew that company over 12 years. And then after that, I created in a completely different industry, in the plastics industry, I created a spill-proof disposable lid for kids that I wanted to sell to restaurants.
So great. And I want to focus on this creation of a spill-proof lid. What was the original idea behind the invention, and how did you realize that it was something worth protecting legally?
Yeah, for sure. It was definitely a globally unique design. When I create anything, I do my market research. I mean, I really have no interest in these already high barrier of entry industries and competing with the largest corporations. And so um, when I go to create, it's like, does this exist, first of all? And with technology, that research can be done very easily. And so at the time that I designed the lid, I had a 2-year-old daughter. We went out to eat often. She had sippy cups at home. And so everyone knows what a sippy cup is. And so I was tired of going to the restaurants. We would get a kid's meal. They would bring out a cup and a straw and she would tip it up and it would spill because that's what she did at home. And so I thought, I wonder if I could create like a disposable sippy lid for restaurants, disposable slash like recyclable. And by the way, could that lid be spill proof? So when they knock it over, which happens 100% of the time you're out to eat, will the lid not pop off and will it not spill? And so that was really I would say the genesis of the invention. It was just I wanted to solve a problem as a mom. And once I finalized the prototype and really saw that there was nothing out there. Plus, this was around the time when institutions were going strawless. I was like, this needs to be protected because not only did it look a certain way, it functioned a certain way that really didn't exist that I could find. And after doing a patent run, like patent search, like we saw that there was nothing even similar in the patent system. And so very quickly I knew I had to get a patent attorney and protect it as much as I possibly could.
Makes so much sense. It's a huge problem with spill-proof lids. I've
Yeah.
never seen one that actually it's fully spill-proof.
Right.
And
Yeah.
for listeners who might not know much about how to get a patent, what does the process look like from the perspective of an inventor like yourself?
So, definitely patent law and patents, I would recommend getting an attorney. There are some things that, especially with technology and protecting your business, and even with AI and ChatGPT, there are things that you can do online to protect your business. But with patents, it's a very legal and scientific process where either you as the inventor, or if you have a contracted engineer, let's say, that's helping you design a product, they work hand in hand on um, really protecting your creation to the best of their ability. And so I would say get an attorney. Um, that doesn't mean it's a crazy expensive process. Not anymore. Like I said, there's so many platforms that there's lawyers for hire that can help you with the filings. But especially if you have a novel product, it's critical that those filings are correct. And so, number one thing, not saying it just because I'm on your legal podcast, like get an attorney, have an attorney advise you. A good attorney will give you great advice further on, if they run a patent search, they'll say, hey, there's something similar. Here may be your odds of gaining the patent or not, which could also save you a lot of money. So first and foremost, get a professional to help you.
Great advice. I think getting an attorney for most legal issues is always a great first step. And a lot of people, or at least myself, I think when you apply for a patent, hopefully you receive it, your idea is fully legally protected. Based on your experience, is that actually true that when you apply for a patent and hopefully receive it, your idea is protected?
I've spoken about this on other podcasts, and I say that I'm going to speak out of both sides of my mouth right now, because although patents are important, especially for smaller creators, they can't really protect you from much. And so let me elaborate. In my case, I got a design patent on my lid. A design patent covers just how a product looks. And if you have a company, especially a very large company, who really likes your idea and they want it for themselves, um, they can design just a little bit around your design. And suddenly you don't have you have a copycat product in market and you don't have a patent case. I mean, it's nothing you can pursue. Now, if you're creating something and you want to put patent pending on, all of your sales and marketing materials, I think that's really a powerful consumer sort of warm and fuzzy. They're like, "Oh, this is really novel." I mean, it's if it's patent pending, really doesn't exist anywhere else. And I think there's a lot of sales and marketing that goes along with a design patent, but legally, I really don't think it protects you from much. Now, if we talk about a utility patent, which is how your product functions, how your technology functions, what your technology accomplishes, what your product accomplishes, how it works in those accomplishments, that's a much stronger legal protection. And so, definitely, if you have a product that's novel in that way, it's novel in what it delivers to the consumer, then a utility patent is a very strong legal protection. So I would say not so much on the design side. I mean, you need both. Not so much on the design side, but definitely on the utility side. Like that's a must.
Great explanation. And so there's multiple types of patents that most people probably don't realize, but you might need both. You can't just apply for one and then have your idea fully protected. It's my understanding that there was actually a legal dispute involving your invention and intellectual property. Without getting into anything confidential, could you walk us through how that situation first began?
Yeah. So when in the very early stages of my of growing my lid, it was called JoJo cups. That's what it was branded. So the creation is the lid, but the product is a cup and a lid, right? That I was selling. And so when I was in the very early stages of that, I was exploring ways to start creating sales. And so I was meeting with people. The product was not for sale, but I was meeting with people where I was putting the product in their hands and I was putting marketing materials in their hands. Um, I was trying to hire sales reps, like things like this. And so I was contacting large manufacturers, including the defendant in my case. I contacted that manufacturer about helping me create or helping me manufacture the product domestically. And so within a very short amount of time of me doing those things, the corporation had a copycat product in market. And again, strawless lids were not a ubiquitous thing in the children's category at that time. And there were there's other design similarities between the two products that literally you couldn't see my product on the internet and decipher that. Like they had to have it in hand. And by the way, a manufacturer to turn around a product that quickly and put it into market is really unheard of unless they have a product in hand that they want to copy. And so, my allegations are that they got their hands on my materials unlawfully and copied the product and put it into market as their own. And unfortunately, they took it a step further. Um, Once they had the product in market, they applied for and were granted a utility patent. Early on, I did not get great advice from my patent attorney. My patent attorney said, you know, don't go for the utility patent. They're very hard to get. They're very expensive. It's time consuming, and you probably won't get it anyway because she's an attorney. She's not a business person. She's not a creator. She didn't really realize how novel my product was. She hadn't done the market research like me, but I took that advice and I didn't pursue the utility patent. So I think what the most painful part of the copycat product in market for me was seeing that they got the utility patent. So at this point, even if I wanted to compete, even if I wanted to say, well, my design's better, I'm legally precluded from manufacturing it because our lids function the same. And there's just, like I said, design specifications that are so similar that could not be deciphered just by looking at the product. And that was the beginning of my legal battle. I thought, this was my creation. This was my hard work, all of my assets put into this. And it's not up for grabs just for anyone to take and as theirs and to sell. And so I'm in litigation now against that corporation. Unfortunately, I had a situation where the attorney on my case, during his representation of me, was negotiating employment with the corporation's law firm representing them. And so there was a conflict of interest, and I'm claiming breach of fiduciary duty and things like that. So I'm in litigation against my attorneys who I hired to protect me, and I'm claiming did not. And I'm also in litigation against the corporation who I'm claiming, yes, unlawfully copied my product.
So it sounds to me like once you get a patent for your invention, like the other corporation did with the utility patent, that doesn't mean that they have exclusive rights over your invention. There's still legal avenues that you can take to make sure that your idea, even though you didn't get the utility patent, it still can be protected.
Yeah, so that's a good question. So if a company unlawfully creates a product and gets a patent on that product, and it can be proven through litigation or through investigation from the patent office or through the patent office, if it can be proven that they unlawfully replicated someone else's product and then went and got a patent on it, that patent is void. So that's a long and expensive process, but it doesn't guarantee, if my allegations are true, it doesn't guarantee that they just now own the rights to this design, right? And so that's obviously what we're hoping the outcome will be in our litigation is that really the patent is not valid. It's grounds for invalidation. If they took an oath saying, well, this is an original design. When you get a patent, by the way, you have to sign, you have to take an oath that this is my creation. It was not stolen. It's original. And as I said, if it can be proven that that's not the case, then that patent is not valid. And so that's another legal avenue for sure. But as it stands now, with them owning the utility patent, if I decided to produce my product and sell it in market, they could sue me for patent infringement. And so, yeah, I really don't have a legal path as it stands now to produce my product.
And one thing that's really standing out to me is you talk about the cost of the lawyers of the patent process. So focusing on that patent process, would you say that the financial cost of getting a patent is one major burden for many young entrepreneurs?
1000%. It can be expensive. It's especially on the utility side, such a critical protection, and worth the investment that, a lot of people just bypass because they're like, well, what are the chances of a corporation like knocking me off? That's not going to happen. I like to argue with that mentality when people are out there saying, "Oh, that just doesn't happen very often." It's not true. It's happened in both of my businesses, especially if you're creating something novel. So it's an important protection. I definitely think that for any entrepreneur who's on a shoestring budget, um, it's a difficulty for sure, and especially in the early stages of a business. And then beyond that, you have corporations who, even if you do, let's say I did have a utility patent, they may knock me off anyway because they know that patent litigation is expensive. It can go on for years, and they can just bleed you out in paperwork. And so that's why, I'm really making the rounds and happy to discuss my case and what I call corporate piracy because I really love to change the ecosystem and the line of thinking, and that, the legal system benefits the largest competitors instead of the smallest creators. It's not right. And these companies have enough money and talent and resources to develop things on their own. And so to just take things um, without buying them is not right. And so I think we need to have this conversation about um, really changing corporate behavior rather than just taking and betting that the underdog entrepreneur, because they don't have the resources, because they don't have the funding, won't pursue me in patent court.
There does need to be reform to the financial burden of patent law as you're explaining it, and it makes more sense to me. If you could reform one thing with how patent law is currently set up, what would you choose?
Definitely, 1000%. The uh, the patent office, so many things. The patent office doing a better job of listening and giving access to small creators. Like every government entity, there's so much red tape and there's such a slog of cases, and there's, it's such a timely process. I wish that the processes from getting the patent to, approaching the patent office because there's been piracy or a copycat to resolving those. I wish it was more small business friendly, small creator friendly. I have colleagues, I haven't as much, but I do have colleagues that are actively lobbying for so many reforms in the patent office, most of which I can't speak to. I can just speak from my own experience, which is it's a very, very long process. It's an expensive process. And then it doesn't even necessarily, it's not bulletproof. It doesn't fully protect you because those with the most resources almost always win out. And so God, I would love the patent office to be advocates for small creators, advocates for small businesses, have some sort of access point for them other than through just tons of attorneys in hearing their stories and reforming that way.
Makes sense, an equal playing field, and I think that's such a great message because it shouldn't be like this David versus Goliath situation where you have to, battle these huge corporations and most small inventors that have this really good idea. They just maybe just don't have the funds. So after everything you have experienced, would you still encourage people to pursue inventing and entrepreneurship?
Always, always. I mean, it's such a, even with uh, the setbacks that I've experienced, it's such a fulfilling and at times really fun process of creating. And then, to take it a step further and see consumers enjoying your product. I mean, there's no greater joy, honestly. And it's the joy in what we do as creators and entrepreneurs that get us through these tough times that um, accentuate our best days and that also get us through our worst days. And so, yeah, I mean, even though I'm a cautionary tale, uh, I truly do believe that as we continue having this conversation, that we can get more corporations on board embracing creators, minority creators, female creators, underdogs. And that would allow for more people who, whether they just like to create or they're trying to achieve financial freedom in their creations, like, are at liberty to do that and feel safe and enjoy it. Because the reality is like, my legal battle is pretty unique. And I say it all the time. For like every one of me who fights back, like the thousands of others just go away. They're like, bummer. I can't fight it. What am I going to do? And there's so many other difficulties in growing a business and being an entrepreneur. It's like we don't need one more thing. And it has to be a positive process. I mean, our greatest inventions and technology that we use today, like these people felt safe creating. And so, yes, absolutely do it, enjoy it, embrace the fear, embrace the painful days. You'll do nothing but grow from it, and it will all work out on the other side.
I think that's a perfect message. That concludes the questions I have for you today. Thank you, Miss Sima, for joining me today and breaking down the legal side of being an entrepreneur. It was a great conversation, and I really appreciate your insights.
Thank you. Thank you so much for having me and sharing my story.
Of course, if you liked this episode, make sure to follow or subscribe to Wahl on Law so you don't miss any future episodes. You can also sign up for our email list at wahlonlaw.com to get notified whenever a new episode drops. Thank you again for listening, and I'll see you next time on Wahl on Law.